So now we'll discuss question number 42. That is when a mortgage property can be sold without intervention of the court subject to what conditions is the power to be exercised? What is the effect of such sale? Can these conditions be valid by agreement between the parties? Explained and examined. So the very answer we found under Section 69 of Transfer of Property Act. So the very sale without intervention of the court is English mortgage, and neither of the parties is Hindu, Mohammedan, or Buddhist, or as provided under the provisions of Section 69, the ordinary rule is that the mortgagee must sue for foreclosure or sell through court, or he can also sue for the mortgage money, but in certain special cases as provided under Section 69 of Transfer of Property Act, it gives the mortgagee the power to sell without recourse of court. Section 69 so lays down three cases in which power of sale can be validly exercised by the mortgagee, and they are as follows. The first one, where the mortgage is an English mortgage and neither of the parties is Hindu, Mohammedan, or Buddhist, or a member of any other race, sect, tribe, or class, from time to time as specified by the state government in the official gazette, and the second one, where the mortgagee is the government and the deed confers an express power to sell, and the third one, where the mortgage property or any part thereof was on the date of the execution of the mortgage situate within the towns of Calcutta, Madras, Bombay, or in any other town which the state government may specify in this behalf, and they did contain an express power of sale. So, the very effect of such sale, now we'll discuss the effect of a sale under a power of sale is to destroy the equity of redemption in the land and to constitute the mortgagee exercising the power of a trustee of the surplus proceeds after satisfying his own charge first for the subsequent encumbrance and ultimately for the mortgager. The estate, if purchased by a stranger, passed into his hands free of all the encumbrance. So now we'll discuss the very conditions for exercising this power. So subsection 2 of section 69 provides certain conditions to be observed before the power can be exercised. And these conditions are: the first one, the power arises when default is made in payment of the mortgage money on due debt where no time is fixed for prepayment. There can be no default till a demand is made for it, but in no case can the power be exercised till after 3 months notice to the mortgager. And in that connection, we would like to discuss one important leading case, and that is Maucherji versus Noor Muhammad Bhai in 1893. The Bombay High Court expressed that the requisite notice may be given to the mortgager or any of several mortgagors where there is a number of them. The very defendants were the first mortgages, and the plaintiff were the puissant mortgages of the property. The property had been advertised for sale by the defendant several times before the plaintiff took any step in the matter. In 1893, the defendant advertised the mortgage property for sale, but the plaintiff contended that the defendants had no power to sell at all because the mortgage deed provided that notice should be given to the mortgagors or their assigns, and the defendant had not given the notice to the plaintiff. It was found that the defendants had given notice of sale to the mortgagors 3 days before the plaintiff had any interest in the equity of redemption. Justice Starling, while deciding this leading case, observed that as that appears to me to be a proper notice, I would not think that any further notice would be required to be given to any person who at that time was not an assigned in order to enable the defendants to sell under that notice, because I am of opinion that an assigned must take things in the state in which he finds them and cannot claim to alter rights which have acquired before he has any authority to interfere. Where the default lies in the payment of interest, the power can be exercised only if the interest amounts to at least Rs 500 and has remained unpaid for 3 months. And the second condition, that is, mortgagee cannot himself purchase the property. So, if mortgagee exercising the power of sale as per this provision under subsection 2 of section 69 exercising the power of sale by the mortgagee, he cannot himself purchase the property. And the third condition is that arrear of interest, if amounting to 500 rupees for 3 months after becoming due, in case of interest on the mortgage amount, this power can be exercised only when the arrear amounting at least to 500 rupees is unpaid for 3 months after becoming due. And in that connection, already we have discussed the very important leading case, and that is Mocharji versus Noor Muhammad Bhai in 1893. The Bombay High Court, as the judge in this very leading case, Justice Statling made the observation, and the observation already we have discussed in length. And again, we are touching the very observation made by Justice Statling. That is, as that appears to me to be a proper notice, I do not think that any further notice should be required to be given to any person who at that time was not an assigned in order to enable the defendants to sell under that notice, because I am of opinion that an assigned must take things in the state in which he finds them and cannot claim to alter rights which have accrued before he has any authority to interfere. So, this would be the correct and appropriate answer to this particular question, which question number 42, which asks when a mortgage property can be sold without the intervention of the court, subject to what conditions is the power to be exercised? What is the effect of such sale? Can these conditions be valid by agreement between the parties? Explained and examined, and as we have already explained and examined the very questions relating to question number 42 and the very provisions of section 69 and subsection 2 of section 69, as regarding when sale would be without intervention of court, such as English mortgage, and where neither of the parties are either Hindu, Mohammedan, or Buddhist, or belonging to any race, sect, tribe, or class, who should be notified from time to time by the state government in official gazette, and where the very mortgage is the government. So also the mortgage property, when it is situated either in Calcutta, Madras, Bombay, or any other towns which the state government may specify in this behalf, and the deed contained an express power of sale. So also the very conditions required for exercising of this power, as in case of default in payment of the mortgage money and due debt. And then another condition is that the mortgagee cannot himself purchase the property which would be put into sale. So also, if there is another condition, if the area of interest is amounting to 500 rupees for 3 months after being due date. So these are the conditions for exercising of this power, and in that connection we had discussed the most important leading case relating to this provision under section 69 is Maudhurji versus Noor Muhammad Wai in 1893, decided by Justice Statling of Bombay High Court. And then we would like to discuss question number 43, and which is discuss the essentials of an English mortgage and the remedy open to a mortgagee in such a mortgage. So, in that connection, we would like to discuss the essentials of an English mortgage. An English mortgage is a transaction in which the mortgager binds himself to repay the mortgage money on a certain date and transfers the mortgage property absolutely to the mortgagee, but subject to a provision that he will retransfer it to the mortgager upon payment of the debt. Thus, the main features of these mortgages are: the mortgager should bind himself to repay the mortgage money on certain day. Second one, that the mortgaged property should be transferred absolutely to the mortgagee. And the third one, that such absolute transfer should be made subject to a provision that the mortgagee will reconvey the property to the mortgager upon payment by him of the mortgage money on the appointed day. So, an English mortgage resembles a mortgage by a conditional sale insofar as both of them belong to that class of securities in which the ownership of the property mortgage is liable to be transferred from the mortgager to the mortgagee on default of payment. So, as it is provided under Section 58, Clause C, and in that connection, we would like to discuss a leading case, Ram Kinkar versus Satya Charan, decided by the Privy Council. As it may be noted that the word absolutely in the definition of an English mortgage in clause C of section 58 seems inconsistent with the definition of mortgage as provided under clause A of the same section, which says that a mortgage is a transfer of an interest. So, in this very leading case, Ram Kinkar versus Satya Charan, the Privy Council held that the definition of an English mortgage as given in the Transfer of Property Act under Section 58 must be read subject to the definition of a mortgage as given in Clause A of that section. So, in that connection, their lordship express that this section 58 clause C speaks of the mortgager transferring the mortgage property absolutely to the mortgagee. In using these words, does it mean that no interest or no legal interest in the property remains in the mortgager? Their lordship cannot think so. If the subsection stopped at the word mortgage, it might be necessary to put the construction upon it, but it does not stop there. it adds the provision that the mortgagee will transfer the property upon payment of the mortgage money as agreed. So their lordship think that with this addition, the subsection, upon its true construction, does not declare an English mortgage to be an absolute transfer of the property. It declares only that such a mortgage would be absolute were it not for the provision for transfer. Their lordship continued that if the subsection does not determine what legal effect follows from the use of a particular form of words, it merely prescribes the forms of words necessary to constitute what is known in India as an English mortgage. Section 58, Clause C deals with form, not the substance. So, in that connection, we would like to discuss one important leading case relating to this provision as provided under section 58 subsection C, and that relating to a leading case, that is Jagdamba Company Limited versus Raja Shiv Prasad. So where it was again repeated that in Ram Kinkar's case the question was whether a lessor would sue a mortgagee from a leasee for rent. This he could do if there was a privity of estate between him and the mortgagee. It was contended by the plaintiff that as the mortgage was an English mortgage, there was an absolute transfer of the lease and therefore a privity of estate exists between the lessor and the mortgagee. This argument was rejected for the reasons given above. Why their lordship in this leading case, Ram Kinkar versus Satya Charan, why the Privy Council so in their decision in Jagadamba Law Company Limited versus Raja Shiva Prasad, it was decided the third basic characteristics of an English mortgage is that the provision must be for transfer of the property upon payment of the mortgage money as agreed on a certain date. There must be a clear provision or agreement in the mortgage that as soon as the mortgage money is paid, the absolute interest transferred in the property mortgage shall revert back to the mortgager. So, this should be the correct and appropriate answer to question number 43, which asks discuss the essentials of an English mortgage and the remedy open to a mortgage in such a mortgage, and as we found those provisions as under section 58 clause C, and that also in that connection we have discussed the very essentials of English mortgage and how the very answers relating to an English mortgage as it was tendered by their lordship of the Privy Council in the leading case Ram Kinkar vs. Satyacharan, and how the very third basic characteristics of an English mortgage was held in the leading case Jagdamba Company Limited versus Raja Shiva Prasad. So, this would be the correct and appropriate answer to this question number 43. And in this way, we have completed at most up to question number 43 and all those relevant sections of Transfer of Property Act. So also the important leading cases relating to those answers of those questions. So we have completed up to question number 43, and in our next upcoming video we'll discuss question number 44 and also question number 45.